With Volunteer Lawyers Project, as you guys know, because many of you were involved with it over the years, we used to have a morning of attorney of the morning program. And because there was no right to an adjournment, the cases would resolve that day. In 2019, the law changed really substantially, and it made it so that there was a right to a 2-week adjournment. And with that, we felt an obligation to start adjourning all the cases, because suddenly that meant like we got to look at the case file. We could review the affidavit of service. We could do some informal discovery, because in landlord tenant court, it's not formal discovery. You're not exchanging interrogatories, but you email each other, hey, could I get a copy of the rent ledger, for example? And then you discover that the rent ledger is insane. And then or somebody says, I'm doing DSS payments from, shelter payments from the county, and you start looking at the ledger and there's no DSS payments. So then we've reached out to DSS and get copies of the payments. And so it's really changed the way we are able to defend people, and has made the practice a lot more robust, which is really exciting. Unfortunately, I think due to a lot of circumstances, partly due to the craziness of the pandemic and the coming back and remote schedules and all sorts of stuff, we haven't had a lot of firms agree to shift to full representation on the tenants, because the cases do come back 2 times, sometimes 3 or 4 if you've done counterclaims. And so what I'm hoping to do with this training is open up the idea of doing a pro se clinic at court to help people file answers. And then I also just want to put out there, if anybody wants to take on cases for full representation, if you do the pro se clinic and you work with a client and you're like, I find this to be a compelling case, you can take the return date. Guess what? It'll be 2 weeks later. So it's very straightforward. We would love to have people take on full representation, but volunteering with us, saying today that you're willing, we're hoping Bousquet will do Thursday mornings from 9:30 a.m. to 11:30 a.m. at the court. And saying you'll do that is not committing to taking on litigation, for example. If you're not a litigator and you're like, oh my God, I really don't want to do litigation, that's okay. There's a role for you, because what we've done is we've changed our practice so that we're doing written answers, and pretty robust written answers, to try to equip the tenants with the best kind of arguments they can have with the judge. So with that said, that's the framework of why we're having this conversation today. We are going to go through several different things with what to expect. Folks online, are you able to see and hear us?
Yes.
Okay, perfect. Great. So what to expect? We're going to talk a little bit about why we care so much about tenant rights and why I talk obsessively about it all the time. I was just on a PBS show. I can forward you guys. You saw that? Yeah, the New York Connect. Yeah, I mean, I'm very passionate about tenant rights and involved in the statewide campaign for right to counsel and eviction. And so we're going to talk a little bit why this matters so much. We're going to go briefly over the eviction defense process. I'm not going to do the most in-depth training about every aspect of every defense. We do have common defenses, and we do have some other trainings recorded that are much more in-depth, and also I can provide you with more material. But we're going to talk about some of the most common things. Then we're going to talk about orders to show cause, because that's something that is urgently needed by the community and is not something that is regularly provided by the other legal aid providers. And I have to say, VLP, right? We are providing access to justice through engaging the legal community and volunteer service to those in need. But at the end of the day, folks, what that is in reference to, like what we do when we say provide access to justice, is we look at what the other legal aid orgs are doing and we try to fill the gaps, and we do that with you all, right? So when we're talking about orders show cause, and some of the legal aid orgs do it, but they do it, but a very small number, and there's a much greater need. That's why we need you guys to do it. And we're going to show you how. And same with Article 7D, orders to compel. This is a brand new thing. This only started in December of 2023. In fact, December 30th So when court was closed, it started. So we're still, it's still feeling it out. Most of those cases are like the first cases that were ever filed are still pending. So we're seeing how it works, and I'm going to talk you through that. Okay. All right, so as a reminder, we provide malpractice insurance, and like our malpractice insurance is the primary malpractice insurance. For every 2 hours you volunteer with us, if you want, you can get 1 hour, like 1 CLE credit, pro bono credit. I believe you can apply up to 11 of those every 2-year cycle. If you're newly admitted, you can't, but you can roll them over and use them your next time, okay? And to get those, you just email Bethany at our office. And she always puts out a reminder towards the end of the year. Hey, folks, don't forget to let me know. You just fill out an affirmation and we'll give you the certificate. And then, of course, we provide the support and guidance, okay? So we're not leaving you alone. When you go to do this clinic, Luz Marina will be with you. We have a lot of materials. And then Gregory, as he gets involved, will be there to be a support as well. And if you do decide to take cases on in court and it's your first case or you're still newer to it, Gregory would be there with you and help walk you through it, okay? All right. So why the housing crisis? Does anybody know how to make this thing go away? I always never know how to do that. I'm trying to get it out of the way. Is it under more? Hide panel? Hide floating meeting control. Thanks, George. You just changed my life. Oh my God. 5 years of endless Zoom meetings. You just changed my life. Okay. The housing crisis in Syracuse. If you've been reading Syracuse.com, none of this is going to come as a surprise, but I do think it's important to really highlight it because these numbers, these statistics we talk about have real life consequences for the folks that we are working with in eviction court and quite frankly, in all of our programs at this point. For a long time, over half of Syracuse residents have spent over 30% of their income on housing. That means that their housing is not affordable. To be affordable, it's got to be at or below 30% of your gross income. But about a third of Syracuse residents spend over 50% of their income. So how that plays out in the day-to-day is we have clients that come in, their only income is Social Security, or not even Social Security, Supplemental Security, SSI for disability. It means they were taking in about $900 a month. Rents are really high now. If you can find an apartment for $900 a month, you're lucky. But some of them are in some of the older apartments that haven't been increased. So maybe their rent's $750 a month. And you're like, wow, what an amazing price. That leaves them $150 a month to live on. That is the situation we have with our clients. It is really intense. It is really hard. And the cost of renting an apartment has increased by over 20% a year for the last 2-3 years. So again, client story, true life story. I was doing a training with Syracuse Tenants Union, and one of the tenants said to me, my rent, I've lived in this place for 5 years. Sorry, folks, this is embarrassing. Boop. Let me see if I can I know if I can get Teams to go away. I thought I'd quit it, but it always comes back. Does anybody else? What's that?
It might still be in like the tray, like minimized, like that little carrot.
God.
Like it might just be down there. Looks like you.
It
yeah,
is.
Exit out there.
Quit Teams.
There you go.
Guys, you guys are changing my life. Oh my Lord. Everybody, I'm just gonna work from your conference room from now on. Okay, so how it like really plays out on the day-to-day. This tenant says to me, I've been living in this apartment for 5 years. I do have habitability issues. It's really frustrating, but nevertheless, I was able to afford it because it was only $900 a month. And then my landlord gave me a 90-day notice that he was increasing it to $1,400. What can I do? Nothing. They gave a 90-day notice. That's all they have to do. We don't have good cause eviction in Syracuse at this point. We hopefully will adopt the new law that was passed, even though that was a very, very watered down version of good cause. It at least would cap increases at 10% a year, which would be nice, because a like 60% increase in 3 months is just not
The
possible.
rule right now is just that they have to give the notice based on how long the tenant has been there.
That's
right? For that
correct.
amount. Okay.
That's correct.
This is actually compounded by the fact that historically Syracuse was an extraordinarily inexpensive place
Yeah.
for housing.
It was, but I will say, for example, it was Syracuse has been inexpensive for rental, but it's also been inexpensive to buy.
Right.
And that person's like mortgage did not go up 60% in 1 year, and this landlord made no repairs. And that's what we're seeing, is that these increases are happening without a justification, with refusal to make repairs, and without any reason beyond that. There seems to be a common agreement amongst landlords that fair market rent should be 100% higher than it was. And they're working their way up there real fast. It's also harder to find an apartment in Syracuse right now than in any other city in the entire country. And it's harder here than New York City. And how that plays out is it is taking our tenants on average 6 months to find an apartment. So if you used to be in landlord tenant court and the tenants would say, you know, we can get you a month. Is that enough time? Say, oh yeah, I can get a new place in a month. That's not a problem. No longer the case. I had a client the other day, he applied 38 places before he got it accepted because he didn't have good credit. And the landlords, once the state passed the law prohibiting income discrimination in housing, suddenly all the landlords started doing credit checks. So now we need to pass a law that says you can't discriminate on credit, because right now people can't get apartments. And it's really, really, really difficult. And so these have real consequences and changes in the ways that we advocate for our tenants too, because if at the end of the day, we're always asking the tenant, what do you want? Do you want to stay? Do you want to go? Do you want to fight for habitability? Do you not? If you know, even tenants that want to go can't go anymore. So it changes the timeline of what we're trying to do. And then this housing crisis has real life consequences as well regarding homelessness. 1 in 10 Syracuse City School District students are currently homeless. That means in my son's kindergarten class, 2 of the kids are homeless, and that feels really hard. And it feels hard as a community that is the situation that we're living in. We have the highest rate of homelessness ever recorded in Syracuse by far. And while homelessness in general has increased 40% since 2021, most of that has been family homelessness. And we've had a 65% increase in family homelessness. Not only is the family shelter full and the domestic violence shelter full, but all the hotels that the DSS traditionally has sent families to when there's overflow are full. And so now DSS is having to find new hotels. It's a really serious situation. So when we say, you know, when I'm going to talk to you later about orders show cause to extend time when people weren't able to find a new house, it's because this is what's happening. Like, it's not, people can't find homes and they're ending up homeless. And this is really important. 75% of the people that are experiencing homelessness right now have never been homeless before. It's a really different situation and they're really struggling. So people need us more than ever to help them be able to stay in their housing as long as possible, so that either that place can be safe and affordable for them, or so that they can find a place that's safe and affordable. Okay. This is actually changing. It changed just yesterday. Sorry. It's not going to be 9 to 11. It's going to be 9:30 to 11:30, because the room that the court is giving us, you know, when you go into part 1, there's the attorney conference room on the left. On the right, there's a room they sometimes use for arbitration. That's going to be the room that we're going to be using to help clients draft their paperwork. Okay. It's going to be limited scope assistance, advice and counsel, drafting court filings. And like I said, if you do decide you want to take a case on, you can. You just got to let us know, and we'll have the client execute a ongoing representation retainer, as opposed to the limited scope retainer that will have. The one that we're gonna have right now is more similar to what you'd see at like family court clinic or surrogate court clinic, or talk to a lawyer where it's like advice and counsel only, okay? So just as a reminder, and this should hopefully be like real quick refresher, there's generally two kinds of evictions. There's non-payment. Non-payment is great because you can cure it by paying the full amount and then you get to stay. It used to be that 90% of cases were non-payment and 10% were holdover. That is no longer the case. Approximately 60% of the cases from what I've seen are holdover and 40% non-pay. More of the landlords, when there's any rent due, are like, forget it, I just want you out. So holdovers happen with termination of tenancy, lease violations, and objectionable tenancy. In almost all cases, it's termination of tenancy. The landlord's given 30, 60, or 90 days notice, depending on the length of the time that the person has been living in the apartment. And then that time expires, and then they go into the eviction process. Every eviction has predicate notices, an opportunity to cure, notice and petition, service, hearing, and then the outcomes, either a dismissal or withdrawal, or an order, potentially an order and warrant, potentially a money judgment as well. Okay. Folks, I'm so excited that I learned how to make a graphic. You have no idea. Bethany in our office usually does these, and I did it. This is it's on in front of you as well, if you can't see this, but this is just to try to like, put in a visual way the timeline of how an eviction works. So in a non-payment eviction, the rent's due, it's determined by the lease, it's usually on the first of the month. Under the laws now, you need to do a written 14-day demand for rent. And that can be served, it has to be served. It can't just be like a text message or, oh my God, my favorite landlord tenant story I had in the pre-2019 days was when somebody wrote the demand for rent on the top of a used pizza box and slid it under somebody's door. And that was sufficient. No longer sufficient, folks. Now they actually have to serve people. Yeah, exactly. No, they did not. They shoved it under their door. Yeah, that's no longer sufficient thanks to the laws that passed in, yeah, I know, right? Thanks to the laws that passed in 2019. They do actually have to serve it according to law. But the 14-day demand for rent could be served day 2. They don't have to wait a period of time first. They then have to also provide a 5-day late rent reminder. That only has to be by certified mail. So in practice, how this plays out is the landlords usually serve, after 5 days, they serve a 5 and 14-day notice. And then it's just taken care of, both of them. Does that make sense? Most landlords don't do them separately, but the failure to provide either of them is a reason for dismissal. After the 14 days have expired, so from whenever they did, say they gave the 14-day demand for rent on day 5, they can't file until 14 days after that. It's not 14 days from the day the rent was due. So once that is done, they can file the notice of petition and petition. It has to be personally served between 10 and 17 days before the hearing. This is new too. The amount of time was extended. That if it is served outside of that time, that's also a reason for dismissal. At court, at the first appearance, the tenant may request a 14-day adjournment. The law says it shall be given. Some of the town and village courts, that does not happen. Here in Syracuse, it does. That's not a problem. The answer can be in writing or oral, and the way the statute writes it is you can answer anytime before it is heard. So you can file the answer before the final hearing. So that's usually what we do, is we end up filing the answer between the first and the second appearance.
Question about that for the clinic that you want to do now.
Yes.
So the answers that we're helping people write are new people that just had their first appearance that day.
Yeah,
And
usually
then we're helping them write their answer.
that's usually what it'll end up being. I mean, in theory, we could be referring people ahead of time.
Sure, and they're coming in.
But in practice,
They're
it's probably
okay.
going to be people that are already there.
Okay.
And I'll, yeah, go
Oh,
ahead,
are
Joy.
we gonna help them file that day too?
Yeah, we'll
Okay.
explain to them how to do it.
Okay.
And the important thing to note is that we will also be going over how to request an adjournment, because while the tenant only has to go up in front of the judge and say, I'd like an attorney, our judge has developed, since we stopped having an attorney of the day program, she has developed what I would consider a bad habit of asking the tenant to, on the record, say, she'll go, okay, so we're here for non-payment, says you owe 1,400, do you owe it? And did you get notice? And that's even if the tenant says, I'd like an attorney. So we're gonna explain to the tenants how to respond to that. Say, I'd like to speak with an attorney first, because they're waiving their biggest defenses on the spot. Okay, and then after the hearing, it's either going to be dismissed or withdrawn, or there's an order and warrant issued, potentially a money judgment as well. The order and warrant, it'll either say that the execution is stayed or not. We used to care about issuance versus execution in terms of staying. We no longer care, because since 2019, you can cure up to the minute of execution. So if you pay the landlord anytime, right up to the minute when the sheriff comes to throw your stuff out, then the eviction is stopped.
But the landlord could file a judgment,
They could still do the judgment, but
which I understand.
But then
some
we
of
would
our clients don't
satisfy
have good credit scores, but it doesn't get better.
that's correct. But if they pay the full amount, then the judgment has to be vacated.
But it's still there as a judgment that was satisfied, I presume not vacated.
Right, but it's not, the number of attorneys that actually file a judgment within the 14 days, I've not, most of them never even
Yeah,
file.
again, this is just time sequence. So somebody
Yeah.
comes in, sits down. Do you put an answer in and then request the adjournment, or can you request the adjournment and then put the answer in?
Yes, you can request the adjournment because we request to reserve all
Right.
defenses.
So you don't want to put an answer. You
Um,
want to take the
Yeah.
goal here, based on what you're telling me.
Yeah,
is
to give more
max
time.
More time.
Yeah.
So you want to wait 14 days, put the answer in, and
I mean, realistically, you could still put the answer in and say, I'm still trying to seek counsel. Like you're allowed to put in an answer and still seek counsel. Like you're allowed to
Right,
record
but
one
then-
of the.
But if a lawyer shows up on day 14 and serves the answer,
Mhm.
nobody's gonna do anything because nobody's even read it.
Yeah, I know what you're saying. You're saying, will you then get more time and not?
Right, you're gonna buy more
within
time by
day
waiting until the
14?
14th day to put the answer in. The judge hasn't even read it. You're fine.
I don't think, in Syracuse, I hear what you're saying, and I think in other towns, villages and cities, that might be very important. I think in Syracuse, the judge, so if you, go in for the first day, even if you had filed an answer, I think the judge, if you said, here's my pro se answer, I'm trying to get an attorney, the judge would still adjourn it. You're probably not going to get a written answer from the landlord because they don't really do that. At the next appearance, hopefully they can get an attorney, but over 50% don't get attorneys. So at least they can go forward with what we provided them. Does that make sense?
So I have a question for you about this opportunity to cure
Yeah.
right up into until the execution of the warrant. How does that in practice happen? Because I can picture where the landlord doesn't want to accept, because we have that situation with
Yes.
foreclosure all the time.
Exactly.
Where
Yes.
someone will slide the check across the table and the foreclosing lender's representative will slide it right back.
Yeah.
And say, we are not accepting.
Yeah, and that the answer to that is file an order to show cause. Yeah, and that's one of the three big kinds of orders show cause that we help people with and that
To
we'll
make
want
the landlord accept the rent.
to stop the eviction and make them accept the rent. Yeah, exactly. They are not allowed to refuse the rent. If it's a non-pay, you cannot refuse the rent, but you're there because it's a non-payment. Does that make sense?
Well, sometimes will the lease documents though say something different
Doesn't matter.
in residential? Okay, because in commercial, of course, you accelerate the rent,
Yeah,
just like a foreclosure.
Yeah.
Okay.
Yeah.
So it's different.
yeah, it doesn't matter in landlord tenant.
Question, if it's a holdover
Yes.
based on a violation of the lease term, namely the obligation to pay, and maybe this is why you've seen landlords move more towards non-payment, does that absolute right to cure still apply?
No.
Okay, so, okay,
No, only in non-pays.
okay.
So now we'll move over to holdovers. So holdovers, similar kind of timeline. What changes is the predicate notice comes first. They have to give, if somebody has lived there a year or less, they have to give 30 days notice. If they've lived there between 1 year and 2 year, they have to give 60 days notice. And if they live there 2 or more years, they have to give 90 days notice. And that is true, like, so if they didn't give the right kind of notice and we get it dismissed for that, then they have to do a new notice, right? So that's why the notice, and that is where landlords mess up holdovers the most. Is they don't have good documentation about when the person actually moved in. They don't understand this law, even though it's been around for 5 years. And, or their notices are vague, insufficient, or they give a notice and then reinstate the tenancy and then decide, never mind, I do want you out, but the tenant's been paying the last 3 months, you know? So, since the 90 days expired. So in any case, predicate notice, then the tenancy ends. Landlord cannot accept rent between the termination and the filing. They can accept occupancy after the filing, but they cannot accept rent between the term. So say my lease terminate, they gave me notice I had to be out by April 30th. I gave them money May 1st. They accepted it. Tenancy is reinstated, they would have to start a whole new 90-day notice or 30-day notice or whatever. But if the landlord, so most landlords, if it expires on the 30th, they probably don't get in to file until the 5th, 6th, 7th, 10th, whatever, 20th. Like they don't always go right in. And so you really got to pay attention to if rent was paid, when was it paid? And this is true also of DSS. Like if they are getting payments from DSS, then you can get the payment, like tell them to get the sheet from DSS that says the date that it was paid, and you could say it was reinstated. Yes.
Do you have to make like the full rent payment, like per what the rent is, or is it like if they give them like half the rent?
Oh, no, you would have to, well, actually, they have to, if they accept any rent, if they could accept $1, it's a reinstatement because they're accepting any rent.
Oh.
Now, from the moment, so say it terminated on the 30th and the landlord filed the holdover eviction on the 1st and I paid on the 2nd, they're allowed to accept that because that's considered occupancy. Okay, so it's only in that narrow window of time.
Okay, and the
Wait.
window of time again is.
The time that the tenancy ends until the landlord files the petition. There's this narrow window of reinstating the tenancy. Sometimes it's not a narrow window. We got one thrown out because they gave a termination that ended in December and then they didn't file till March. And they had accepted rent and accepted rent, and accepted rent. So guess what? You know, so sometimes it's not narrow.
This is exactly the kind of thing that people, what most lawyers don't know. I mean,
That's right. And landlords don't know.
Right.
Yeah.
And they often show up, if they're a corporation, they show up themselves.
Oh, that's one of my favorites too.
Right.
Yeah.
Right, sorry.
I love it because you're like, bye-bye. Dismissed. We love a quick dismissal. Okay, and then from there on, it's really similar. Notice of petition and petition have to be personally served between 10 and 17 days before the hearing. First appearance, the tenant may request an adjournment. Answer can be in writing or oral. We're trying to move towards everything in writing to formalize the process and really strengthen the arguments. And then, you know, order and warrant, no money judgment in this case, usually. Okay. And I say usually because increasingly, right, we have started trying to negotiate a lot more time. And if you're negotiating 6 more months, you're going to have to agree to pay some occupancy. And that's an important thing to say to the tenants. If they say, I need 6 months, if I need 2 months, I need 4 months, whatever it is, you're going to have an honest talk with them about, okay, you know, when you talk with your landlord about that, you need to offer to pay occupancy.
I know that
Because
you don't have clients who lie, but I've had clients lie,
no,
and they agree, yeah, of course. So we agree that, you know, they need 4 months, and they're all good.
and they'll say they'll pay.
And then, of course, they don't.
The landlord can then accelerate the warrant.
Okay.
Yeah, so if you agree, if they agreed to pay occupancy and stayed the warrant 6 months out, right?
Yeah.
Which is a not uncommon thing these days. And so we'll say, okay, 6 months, and they agree they're gonna pay by the 10th of every month, occupancy in the amount of what the rent was. And it gets to month 3, you know, they didn't pay, the landlord just essentially emails the court at this point, because you just send it to CIV fax and say, hey, it's got to be accelerated. And we've fought some of those, and we've been successful in fighting some. When there was really severe habitability issues and they had agreed to make repairs and they didn't make the repairs, but yeah, it's an important thing for the tenants to understand. Actually, if you want to stay that long, you're probably going to have to pay occupancy, because it's only the judge. We used to say that would only happen by agreement. That's no longer true. The judge will, over the objection of the landlord in a holdover proceeding, grant additional time, but because the law says that it can't cause undue hardship to the landlord either, she's going to order occupancy, whatever she thinks is a fair occupancy. Now, you can argue occupancy shouldn't be full rent because there's no heat, no hot water, there's broken windows, you know, the windows fall open. These are just like things in the last 3 weeks, you know, sewage in the basement. So she might order less occupancy, but she'll still order occupancy. Okay. So step 1's going to be requesting a 14-day adjournment. In your packets, so there's the handout packet, and then there's like sample forms. So I included this sample form, and we're going to have this printed out in the box. Request for an adjournment, reserving all defenses by pro se respondent. And it's just saying grant a 14-day adjournment, reserve all defenses and counterclaims. The important part, what to tell the tenant. You're going to tell them, you know, where to stand, go up, stand on the right side. Tenants don't really know.
So we're helping them fill this out, and they are taking this up
Up
for their first appearance.
for their first
Okay,
appearance.
what
So
is
if they
how
have,
you get around that?
huh?
Right, that's what I'm.
What's that?
We're not standing next to them.
We're not standing next to
You're
them.
sending them with this.
You're just
form.
sending them with this form. Technically, if you wanted to stand next to them, if you were concerned about their capacity to do this on their own, you can go and say, I am making a limited appearance for the sole purpose of requesting an adjournment. And we can include a form. I do have a form of a limited representation notification that you would give to the court that I will include in the packet for that instance. Most tenants will be able to do this on their own. Again, the judge actually, as a right of course, grants 14-day adjournments now. Judge Tadros and Judge Andrews do not ask the tenants any additional questions. So if it's Tadros or Andrews, you're okay. But Judge Bogan, who sits there 90% of the time, is the one that starts asking questions. And that's what I've raised the concern to her and her law clerks, but I mean, she's well within her rights to do it. And I think her mind is always towards resolving things as fast as possible. But we really need tenants, if we're going to be helping them, to not do that. You know, it just drives me bonkers.
Does
So
this constitute the answer?
no,
Okay, because on the front it says.
No.
Entitled.
no, I know. This is an old thing. Sorry.
Oh,
That's
okay.
just, it's not an answer. This is just
Okay.
just a change in the law. This is definitely not an answer.
Okay.
This is just a request for an adjournment.
Okay.
Okay, limited, I'm making a note that I need to include the limited appearance form. And if you were to do the limited appearance, you'd say to the court, you know, Judge, I'm making a motion to be able to make a limited appearance. The client understands that I would not be making the full appearance, and you know, I won't be representing them on an ongoing matter. We have agreed that this is reasonable under the circumstances, and you just hand them the notice, and the judge will grant it. I can't imagine her saying no.
So I know human nature. If the client or prospective client, the tenant, could say, I don't know if I owe the rent or not.
Yeah.
Right, so they don't need to say, just if they say, I don't know, I need to talk to a lawyer first,
Yes.
I think would go over better with the judge than not answering her question.
Yeah, I think,
And I don't know is the truth.
well, usually what I say is, we dispute if that amount is owed. I don't say I don't know, because Usually the tenant knows pretty well how much they paid or didn't pay. The question is whether or not that amount was owed.
That's what that was my point, is you
Yeah.
get to say, I don't know,
Yeah.
Judge. I need to talk to a lawyer first.
Exactly, that would be a fun thing to
Much-
say. Yeah. And what I would just say is, just say to the judge, you want to talk to a lawyer before you answer. And she's not gonna get upset about that. Judge Bogan understands, she's just trying to move things along. Okay. Number 2, drafting the answer. Folks, we have spent so much time making something that is ultimately very simple. You know how it is, the more you do it, the more hours. Like if you want it simple, it takes more hours. So we have created in collaboration with, this is actually designed by the Northern Manhattan Improvement Corporation, which is one of the right to counsel agencies down in New York City. The right to counsel orgs down in the city are all using this form drafting tool. We went to great lengths to take all the answers, remove all the New York City arguments, put in upstate arguments. It is a work in progress, so you are welcome to make suggestions to arguments, draft new arguments, but this is meant to make things easier. So, for example, in a non-payment, we have 2 versions, either a pro se respondent or VLP representing. The only difference really is that one at the end of the answer would put your name and the other one doesn't. It puts the client's name. So you click on non-payment for pro se respondent. I should say, in the court, in that room at the court, we will have a computer for you. We will have a printer for you. This is all going to be there. Okay. So you click on continue. And then you put in the client's name and the index number. The index number you would get off of their filing forms. If you do not have a copy, you can look it up on Web Civil, which we do have, like we'll have as a link on the computer. If you're not familiar with Web Civil, I'll just show you real quick. You go to it, and probably the easiest, you can either search by the party name, or if you know they're in court that day, you also can look at the court calendar. Because sometimes the landlords misspell the client's name. So if you search the client's name, it might not come up. So you could put in, cases today, and you would put in which part landlord tenant calendar, and then you'd click find calendar. And then just select all, because usually it's just Judge Bogan, but just select all. Those are the 4 that go. And then you're going to see a lot of really great information about the cases.
You click it again.
No, it's thinking. It's thinking and thinking and thinking and thinking. What, are there a lot of cases on today or something? We'll try clicking again. There we go. Okay. So Sam's over there right now with one of our cases. This one's fun. This is a 7D hearing. We got the eviction dismissed, and now we're still continuing forward, suing the landlord for repairs. But in any case, so the index number LT-0000363-24, that's what you're putting in. And you've got the landlord's name right there, so you can pop that right in. All right, going back over to here. So we'll just say, /SY, we'll say 123 Streets, apartment 4 in Syracuse, New York, 13202. Petitioner's name, that's the landlord's name. They're just a bad landlord. It's like Bad Kitty for those who have kids and have to read those stories over and over again. Respondent tenants, you're going to put the client's name in again. And if there's any other occupants, you'd put them in there, like, Teddy Tenant's brother or whatever. OPA firm, you would pull that right off of Web Civil as well. You could see so Raymond doesn't have any opposing counsel. You wouldn't put anything in there. But here, like Mackenzie Hughes, Ward Law Firm is really common. Here it says Matthew Earl Ward, but it's Ward Law Firm. It's the same thing. So it was Ward Law Firm because they represent a lot of landlords right now. And we'll just say that they're at 456 Street. Hospital, New York, and I don't know their zip. Let's say that. If we had their phone number, we'd put it in. We don't have to have their phone number. You click continue. Now, this is the cool stuff, guys. I'm so excited. Answer type non-pay. What are you doing in answer? And then we have the defenses here. And by the time that you volunteer, all of these little circles will have a brief summary of what each defense is. So these match up with, they will match up with these, okay? We're still changing the wording a little bit, but so say there was a violation of the warranty of habitability, and that's part of why they withheld rent. And say there was improper service. Those are good ones. And then if any time there's a habitability defense, I want you to throw in a habitability counterclaim. Because the counterclaim is to demand that the landlord make repairs. And in an ideal situation, what we're going to do is we're going to get the rent paid, in a non-pay, we're going to get the rent paid, and we're going to get the apartment fixed so that they can stay in a habitable apartment. In a holdover, the ideal situation is that they either dismiss the case as being retaliatory if there's habitability issues, because guess what? Most of them are. And, or if they owed rent, they get current on the rent and reinstate the tenancy and the apartment gets fixed. Those are the goals. It doesn't always happen, but that's what you're aiming for. You want, and I mean, always it depends what the client says they want, but I'm just saying at this point, that's the majority of what people want, is to stay and have the apartment fixed.
And from those lists, you're always choosing all of those that reasonably apply.
That's correct.
But in defenses, why are you not raising all of them always?
Because you only want to raise the relevant ones. So
Well, if
You don't know
doesn't
yet.
have section 8. why would
yeah, you wouldn't raise section 8 because you want it to be as
No,
in.
I'm not talking- yeah, but I mean, failure to state a claim.
Mhm. Well,
there's
you will
nobody
have,
in litigation who does not put that in every answer in every law firm. At
so
least
you can
in-
click, failure to state a claim, you can click, that's this big, but what I do want to say is this. We want these answers to be as impactful as possible. And as a result, we know the judge is actually reading them. And her law clerks are actually reading them. But if we start submitting 30-page answers that have no substance to them, they're not going to read them. And so the goal here, since they're a pro se litigant, is to identify the arguments that are really going to have an impact on this case so that they can actually effectively use them, So if you want to, like, we're not going to say defective rent demand unless we know there's unless we know that there's a
What if we
defect
don't?
or we don't know.
Do we know? Most of the time you don't know.
So if the case has already been filed, then the copy of the rent demand is in the file. And you're either gonna send them up to the clerk's office to get a copy of it so we can look at it, or you're right, you can preserve the defense. But ideally, you're gonna have a copy of the court file in front of you as you're looking at this.
And that's after tenants already obtained their 14-day adjournment.
Yes, ideally.
Yeah, so
Ideally.
you've preserved everything that you might want to.
Yeah, but you want us to make a determination
Yes,
if the rent demand was compliant with the law
yes,
before we draft the answer.
that's right. Like, you should hopefully have it there and look at it and say,
And you're
What-
analyzing it.
and you're like, how long did you live in the apartment? 90 days, 3 years. Okay, is this a 90-day notice? Was it served? Okay, we're
All
gonna
of
move
those
on.
things we were doing in the moment previously.
That's correct.
Yeah,
Yeah,
I mean, we were,
literally.
and then we were making direct representations to the court.
Yeah.
That's right. All of that.
Yeah.
And like, if you feel like some of these things might apply, like, you don't have to have a firm proof, but so put in whatever you want to. Put in whatever you want, but I am gonna ask you, at the end of the day, you need to be able to say to the tenant, all of these could apply, but the one you're gonna win with is this. So tell the judge this. Does that make sense? Like, usually I'll go in, I always draft answers now. And I'll go in, for example, we had one last Thursday, and there were 3 defenses, right? It was a holdover, it was retaliatory. They did failure to state a claim because their petition did not actually list out any of the proper information. They claimed it had terminated, lease had terminated in July when they had been accepting rent since July, so they did not state a proper claim. And then there was a lack of rental registry. And I put them all in, you know, and guess what? We won on all 3. But I started with retaliation because it was a case where we had already filed a 7D. So I mean, you just got to be able to say to the tenant, you got a couple, whereas like, for example, if they didn't get proper service and there's also a warranty of habitability, I'm not going to say, go up there and start talking about your codes issues. I'm going to say, go up there and tell them that you didn't get the paperwork. Tell them that it was never served and you found out about the case because your landlord texted you. It's going to get dismissed. You know what I mean? Like, the judge, because of the rate, the pace at which these cases go, the judge doesn't want to slowly contemplate each thing. We had another one. I had a law student helping represent a tenant 2 weeks ago, and it's a self-represented landlord who had done just everything wrong. And we get up there and the judge says, so what's going on here? And you know, landlord starts, well, she wants more time. It was a holdover, wants more time and I can't give more time and this and that. And the judge says, well, you know, counsel, what is going on? And she's like, the counsel, you know, the law student's like, well, we have some defenses, and judges starts getting impatient because we're getting and fine. And I was like, tell her he's not the landlord. And so she says, Your Honor, you know, the landlord on the petition is not the owner of the property. And she says, well, why didn't you say so? You know, and she's like, and what we were trying to get from the landlord was like, I think 4 months. And we had said to him, we need the 4 months. You know, if we can get this dismissed, but we'll save you the cost of filing again and doing surface again by just agreeing to enter into 4 months. Like, she had something kind of lined up. And he was like, absolutely not. No way. No way. And we said, he's not the landlord. And the judge says, well, what was the offer for settlement? Because do you want to reconsider? He did. And we entered order warrant, no judgment, and no, not even any occupancy. And she got to stay 4 months. So that's what I mean, where there can be a lot of, and there were habitability issues there. There's everything under the sun, but the judge doesn't want to hear it all. She only wants to hear the one that's going to win. And so you got to try to help the tenant determine what is the one that's going to win.
Where's the rental registry?
No certificate of occupancy is what we have it written as right now, but it'll say no rental registry or certificate of occupancy, because it depends on the size of the property, right? 1 and 2 bedrooms, rental registry, above that certificate
And how
of
do we find
occupancy.
that? Can we find that while we're meeting with them?
You can on the IPS code. So this is our other favorite.
Is that only the city of Syracuse?
This is only the
think I've
city of
ever-
Syracuse.
Yeah, only.
Rental registry is the city of Syracuse
Got it.
law. Yeah. So, we have a great case that this is the one that was on last Thursday where we won on everything, including rental registry.
Will this be like bookmarked on that?
It will
computer in
be,
there?
yeah,
Okay.
IPS. This is the summary of codes. IPS is the summary of codes. It will be bookmarked. And what you see on the summary page is, several different things. It usually goes chronologically from, the oldest to the newest, except for if they don't have a rental registry or certificate of compliance or certificate of occupancy, COC, they usually put that at the top. But there's kind of sometimes no rhyme or reason to it. So this one, you can see rental registry failure to obtain right there. And this was a fun one because the owner claimed that the illegal rooming house that they were running was owner occupied. No. So they sent in an application filled with lies, and we called codes and said, actually, you should go look. And they went and looked and they were like, oh, no. This is not owner occupied. This is an illegal rooming house. Okay, so you click the things that are relevant. Or if you're Jim, you click everything. We will know when on the days you volunteer that there will be 2 clients, and that's fine. I'm happy with that. I don't need, you can work with just one person and they'll have the most beautiful, perfect arguments. And I love that. There's no
You're
pressure.
also dealing with the dilemma, which back when I used to live in Citicord, legal aid business is in many cases the business of delay. Because it in order to the benefit
Yeah.
of all of their clients,
That's right.
and you don't want us to do that.
No, we do. Delay is the name of the game in a lot of cases, but we have a lot less arguments for delay of the game to delay the game. Like in the city, their 2-week adjournment is usually 3 months because they have such a high volume. And when they then get the adjournment, they have a hearing, sometimes they're adjourning in another 3 months out. It's just a really different landscape. I mean, even now with the 14-day adjournment, the delaying the game is the 7D claim. That's why we're doing the habitability claims, because whereas the final hearing would normally be on that return date, if you file a 7D claim, you're most likely not having the hearing that day. However, you have to tell clients to be ready, because I have had the unfortunate circumstance of showing up not expecting to go forward on the 7D because we had just filed it, and the judge saying, let's just do it. So you got to be ready at all times for all things in landlord-tenant court. They keep you on your toes. We won that one though too, retaliation. Landlord, get this, got really mad at our tenants and terminated the tenancy because they called National Grid when they smelled gas.
Oh.
She was so angry at them. Why didn't you call me? They were like, there was gas.
Yeah.
And National Grid red tagged it. Like it was dangerous. It was they actually turned off the furnace because it was leaking natural gas into the house. And the landlord was furious about this. She couldn't believe it. So a lot of landlords don't seem to understand that they can't do that. Okay, here it says that that an email will come. It's because I'm not logged in. I should have logged in as the housing volunteer. I apologize. You will have a click button that downloads it. So let me see if I have a recent one that I can pull up real quick. That's a similar. Is this one yet? Maybe no. I'm not sure it is. Yeah, okay, so this is the template. All right, let me stop my share for a second since we're actually recording this and I don't. Wait, how do I get back the thing again? Here we go. Was I not sharing that whole time, guys? Oh God, I hope
You were sharing.
Oh,
You're
phew.
good.
Okay,
It's
and I
fine.
stopped the share. Oh my
You're
God.
still sharing though.
I am.
Yeah.
Okay. How am I still sharing if it doesn't say I'm sharing? That's weird. Well, I'll just share the.
Back and do it again so you can learn some more.
I know. Okay, here it is. Here's my right to counsel documents. Again, this will just be a download click for you guys. And then I will share this screen. Okay, so. I can close this back out. Okay, so what you're gonna get then is a Word document that has everything filled in except for, at the top, you still have to do your responses to the petition. The petitions generally have about 7 paragraphs. They're super formulaic. You're just gonna type in admits paragraphs 1, 2, and 7, denies or whatever paragraph, read through them, right? But denies paragraphs 3, 4, and 5, has no opinion, paragraph 7 or paragraph 8 is conclusions of law, right? That kind of thing. So you'll type that in there. And then it goes into this as for a first defense, and it's got the law about habitability, and it cites our PL 235B, which I learned yesterday Tony Gelati helped pass. I didn't know that. How cool. He got an award by the Bar Association. And then it goes on to say, you know, the petitioner has breached both statutory warranty of habitability and contractual obligations, value has been diminished. And then in highlighted is where you got to add some stuff in, okay? That's where you're going to type in, you know, sewage in basements, cracked windows, first floor apartment with windows that do not lock, plywood on front door. Trying to think of some other ones. Holes through floor so I can see basements. Like these are just regular daily things that happen here in Syracuse. Our housing is very old and in terrible condition. Big one that we're really focusing on, lead paint. We now have a law that actually, like, codes actually cites lead paint. That was new. Prior to that, it was just peeling paint. We really want landlords to remediate lead paint. And to be clear, if there are children living in the house and there's a risk of exposure to lead paint, the county has funds to help people. They just got to apply. They're just not doing it.
What is lead paint, when you're putting it in the answer, are you're just taking the tenant's word for like, I think this is lead paint, or, you know?
If
like,
well, in codes, it'll cite it now.
Okay, so
So,
we should see that.
Yeah,
Okay,
if they say there's habitability, the first thing you should ask is, have you called codes?
If
You
the
don't
building was built
have-
Before 1978, there's peeling paint, then there's lead paint.
That's correct.
Fair, I just think that a lot
Yes.
of tenants don't know when
No.
the house is built, but yeah.
But there's been a lot of education and a lot more people are starting to know about it, but it's right. If the building was built before, what is it, 78, you said?
Yeah,
78.
Yeah, 1978, and there's peeling paint, there's lead paint. And you know, they never can really fully remove it. That's why it's remediation. Basically, what landlords do is they are supposed to bring in an EPA certified remediator who will wipe it down, scrape it down properly in a way that sucks up all the dust and then repaint it.
So for residential sales of properties from 1978, we have to attach the lead paint
Yeah.
disclosure form to the contract.
Yeah,
Shouldn't these leases
they do.
all have that?
They
attachment?
legally
Like,
have to have that attachment, but that doesn't relieve the landlord of the responsibility to remediate the
But
lead
so-
paint.
Okay.
Yeah, and in many
don't-
instances, they
you
know
can See a
about it.
picture of the house and decide how it is.
Fair, yeah.
Well, you
Yeah.
can go on
And in
image
Syracuse,
mate and actually it'll tell
You can go on
Right,
image
yeah,
mate
yeah,
and
yeah.
it'll tell
Yeah.
you, but
Yeah.
you can also just assume it is. So, and also an important thing to know about 235B with the warranty of habitability is, it used to be you had to report it to a government agency. You no longer do. You only have to report it to the landlord or the landlord's agent, you know, their property manager. And that's something that comes up in court a lot. The landlord will say, well, they didn't report it. I have had attorneys argue in court. Well, they didn't report it to codes, and it's like, that's not what the law says. So stop saying that. Go
I've heard
read
the-
the
I've heard
law.
the judge say that too.
Yeah, the judge prefers codes. And so if they are coming in and reporting habitability as a defense, and they have not called codes, tell them to call codes, because the judge really prefers to see
Can you
that.
just please do a form so they can put the address in and sign it and put it in the mail?
For codes?
Yeah.
You actually could do it online. You can report it online.
Yeah, I'm just saying in terms of, if somebody comes in and sits down.
Yeah, a form to
is it,
help them.
You know, is there peeling paint? Sign this. You have it money for a postage stamp. Can you put this in the mail? Here's an envelope, whatever system you want to put in place, and then put it in the mail.
Yeah,
You don't have to wait to see if they go online. They won't go online. You know they won't.
No, I'm
go
saying
online.
you could go online with them in that moment, because we'll have internet
While you're
access for
meeting
this
with
while
them.
you're meeting with them to report the codes. Yeah, that's a good idea. Thanks, Jim.
Sort of came-
I know, and I'm appreciating you. Okay, failed to serve the petition and notice the petition in accordance with our PAPL 735. That's like the 10 and 17 day thing. You could also add in the CPLR, what is it, 308? Come on, litigators. I think it's 308. That's got the regular service rules, because both of them apply, right? It's still, yes.
You look in the file to see if there's an affidavit of service on file. If there's not, then we did.
That is what I would assume. Yeah.
Now, if we're able to get this list, get some kind of failure of notice or service, how quickly can they get back in court, or do they start all the way back over? What's the procedure?
It depends on whether or not the reason for dismissal was improper notice. Because if it was improper notice, then they got to renotice everything. If it wasn't improper notice, then they gotta refile it, but they still have that, like, the filing, and then they gotta wait 10 to 17 days. You get back into court, you're entitled to another 14-day adjournment. So you're still buying somebody about a month and a half, at least, with that. Mhm. Yeah, I think that Lori had calculated it out as 52 days from the time of missing rent until the earliest that you could be evicted if you would get an adjournment under the new laws. Okay, so it creates this for you, and then it puts in a where for, and you're gonna be putting in the client's information. We do have the counterclaim, and I am gonna be making one small change to this. I am gonna make it a verified answer, and the reason why you don't have to verify answers, but the counterclaim 7D does say that the petition should be verified, so I'm just gonna throw a verification on all of our answers, so you have it. And so bring your notary stamp, pretty please. Okay. And if we're successful with the advocate, so I'm part of the VLP is part of the New York Legal Services Coalition, which is a statewide coalition of almost 50 legal aid orgs. And one of the bills we're trying to get passed at the end of session is a correction to the notary. You know how the notarization law changed and said anything that previously had to be signed affidavit can be affirmation? When that law was passed, the authors, us included, believed that it was going to remove the notarization requirement from verification, but OCA interpreted it to mean no, because verification's under a separate section of the CPLR. And so we are trying to get a fix.
But also,
Passed
to
this year.
verify it, they have to verify the reply.
That's a good point. And that's nice too.
And that's a hassle.
And that is a hassle.
Yeah.
Oh my God. Jim, I need to bring you in more often to come up with more ways to hassle landlords. This is awesome. You're good from zero to zero? I love it. This is amazing. Yeah. So we put in a lot of hours of work to make it so it's a click, 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 go. And I'm hoping it's going to work well. And but it's a work in progress. The downstate agencies have not just the answers, but they have an order to show claims, motions to dismiss, like all kinds of, and all kinds of, yeah, right? Well, they got a lot of people, right? They have a right to counsel down there, so they have a lot of people. We're working our way there, and we will try to get there, but we're not there yet. Okay, so we're gonna go back. Folks online, can you see where we are with the PowerPoint again?
Yes.
Okay. Good.
Yes.
Okay, so then step 3 is going to be file and serve the answer. They either can we'll make copies right there. Assuming it's done and notarized, we'll make copies. You can tell them to go up to room 130 and they can file in person. And then we will help them serve it on the opposing party. We'll have letters that are stamped because clients don't always know that they can't serve it, right? So we can just do mailing service and fill out an affirmation. Or you could help them file via the EDDS. If you're familiar with EDDS, it's super easy to do it. And but then you do still have to serve the opposing party. Basically, if the person is represented by an attorney, we can just send them an email and say, hey, we just helped this person file this answer. If they're not represented by an attorney, you really got to mail it to them.
And then we need to do an affidavit of service.
Affirmation of
Affidavit
service.
Yeah.
Now it's an affirmation, which is
Oh,
great.
it is an affidavit.
Yeah.
Okay.
No, wait, no, you're agreeing with each other.
Yes.
Are you saying it is an affirmation of service?
Yes.
Yeah,
Yeah.
you're saying, telling her, not telling you.
We're both
No,
agreeing.
No, yeah.
Yeah, okay.
Yeah, we're agreeing.
Yeah.
It was a point of,
I've been gone for, so
Exciting.
I was still saying affidavit on accident.
Yeah. Okay. And then we have instructions of what to tell the tenant on the second appearance. This is assuming they don't get an attorney, which again, about 50% of people are not getting attorneys at least, if not more, depending on the day. How many, I mean, that's what you see too, right? Yeah. So the judge will have read the answer and counterclaim. She's really good about that. She starts at the beginning saying, oh, I see an answer has been filed and whatnot. It's really important that you counsel the client about being super clear about, as we would say as lawyers, their theory of the case, right? And what they want their outcome to be. Do they want to stay or do they want to go? It is, I think, from my observations of how the judge reacts, there's little that is more frustrating to the judge than somebody waffling back and forth about whether they want to stay or go when they're up, standing in front of her, because she's like, well, do you want to go? Do you want to, she gets really frustrated. So have them really clear. I want to stay. And the judge will pressure people to agree to leave. But if they want to stay, they got to say, I want to stay, and if they want to stay, they need to be really clear how much time they need. And when you say that, if they haven't looked for an apartment in at least 3 years, make sure they know that it's going to take them 4 to 6 months to find an apartment. Because not everybody knows that. We've had people who had an apartment for 5 years. They come in and they say, yeah, I probably need a couple weeks to get an apartment. I said, have you looked for an apartment yet? And they're like, no. And I'm like, you need more than a couple of weeks. You need a long time. You're not going to find a new place that fast. Even people with good credit are not finding places that fast. We encourage people to try to talk to the landlord. The judge always wants people to have tried to settle it ahead of time. And if the landlord won't negotiate, just go in front of the judge and tell the judge what you want, and that's, make sure that they're armed with their very best defenses and encourage them to bring proof. Rent receipts, pictures of the code issues go a long way. Code violation printouts go a long way. And to the extent that we can help print any of that, we'd love to.
If they bring it with them, can we attach it to their answer?
100%, that'd be ideal. I'm gonna go into order to show cause.
Well, I don't know how much time.
We've only got 15 more minutes, I think, at this point.
So if it, just because this is sort of out in left field, if it's a family member that's evicting a family member, you can't do an eviction. You have to do an action for ejectment.
I love that.
It's Supreme Court.
So
I think we've had that with
Okay.
the states.
what is the,
So
Yeah.
when I have dealt with this, mom dies,
Yeah.
Junior is
Right,
living in the
that's-
house.
Oh, yeah,
Thomas
yeah.
Junior is living in the house.
Yeah.
You have to bring an action for ejectment. You
Yeah.
cannot bring an eviction.
Yeah, we
But it's
have
still
seen.
saying if mom is there and she wants Junior out, it's not an eviction.
Well, you're right
thought
about the
they said
ejectment when they passed. If they're alive, it depends on if it's landlord tenant or not.
Let's just say it's a good question that
Okay.
we're not gonna finish in the next 14 minutes.
That's right. Yeah, because we have,
Yeah,
it's something to
exactly.
think of.
It's a flag. to put
yeah,
up.
it's something to think
Mom
about.
is kicking me out.
Okay, so I want to hit orders to show cause in 7D real quick, okay? Orders to show cause, we don't have it in our system yet, so what you're gonna be having there is a paper version that I'm gonna update a tiny bit in the next 48 hours. But essentially, I gave you a sample where you write it in. There are the 3 most common orders to show cause that you're gonna be dealing with are vacating a default judgment, which is just the same CPLR section as any other civil litigation. And the courts interpret reasonable excuse very, very broadly because there's a public policy, there's public policy towards favoring having people's cases actually heard and not going forward on default, right? So that's the example I've provided here in the materials, and folks online will get you these materials. I'll scan them over to you. So here, you've got the order to show cause, you're writing it in. The thing I need to update is that the court usually, especially if the landlord is represented by counsel, only requires service by email now. So I do want to put that in because that's pretty critical. And we also only serve the marshals via email now. We don't have to drop off stuff in person. And I actually wrote the marshals emails here on the sample for you.
I have done service by Facebook.
Good
I got
times.
4 orders.
I have, the weirdest one I've gotten is I did service by WhatsApp once. On somebody in El Salvador. But that was not in an eviction case.
No,
That was in a
I
family
don't
case.
think mine was in an eviction case.
Okay, so affidavit in support of, Julia has some materials. Thank you. So this one, the example I gave is a CPLR 5015. Literally, you just got to do like a tiny thing here saying which law you're citing and what the reasonable excuse was. So this is like, my reasonable excuse is that I was in the hospital. That's a really common one. Our clients tend to be have a lot of health issues that are associated with living in really poor housing, for example, that result in being in a hospital. So you just put that in, and then if you're doing it as a reasonable excuse, you should also include an answer that has the meritorious defenses. That's same as any civil case. If it's 50-15 lack of jurisdiction, aka they weren't served, they never got the notice, then in theory, you're like supposed to include the motion to dismiss with that. We usually just do an answer that's got the defense of the motion to dismiss. It's treated the same way, really. So either way, that vacate, you're going to attach an answer. So you're going to do the order to show cause and an answer. When tenants do these on their own, they don't include an answer because they don't know they need to. And because you could do an oral answer, it's not a big deal. It's not going to be, these are not, I mean, the judge will always grant I shouldn't say will always. I have not yet seen the judge not grant the order to show cause to bring the case back. And then once it's back on the calendar, it's just the same as any other case, okay? But we want to do best practices. That's our goal. That's what we're going to attach those answers. Vacate the warrant. This is the one that we were talking about where you have tried to pay and the landlord refused to take it, or you paid and the landlord's still trying to go forward on the warrant. And so again, you would just cite RPAPL 749. Tenant has paid the rent in full, or tenant attempted to pay the rent in full and landlord refused payment. You don't need to attach a warrant to that one. You're going to stay or vacate the warrant or if the warrant had already been executed, like if this was the day after, you'd get restored to possession. Now on those ones, if the if the landlord is represented by an attorney, before you go through the whole headache of doing an order to show cause, you can call or email the attorney's office with them if you want. There's a phone right in there, and say, hey, did you guys vacate this? Because they don't always tell the tenant that they did. So we had one just the other day where somebody came in and said, I paid him, I got DSS to pay in full, but the warrant was on my door. Am I going to get evicted? And we were getting all geared up to do an order to show cause. And then we called the attorney, and the attorney's like, no, they paid, it's fine. And we were like, did you talk to the marshal? And they're like, oh yeah. They just didn't let anybody know. So take your time to actually verify it if there's an attorney on the other side. If there's not an attorney on the other time, don't take that time. Just do the order show cause. And because usually if they don't have an attorney, it's extremely adversarial. Request additional time, good cause stay. This is what I was talking about. This is what I just recently did with the client who had applied to 38 places and can't get into a place until July 1. And so we did bring an order to show cause to extend the time because he had agreed to a warrant that would be out by March 31st. So we brought the order to show cause. And with these ones, always, if there's an attorney on the other side, reach out to the attorney first and ask them if they'll consent, because many times they will consent as long as they're willing to pay occupancy. But sometimes they won't consent, and then you're going to have to bring it. And the judge is quite sympathetic to these at this point because she's very aware of how bad the housing market is. So in that case, we ended up having to bring it because the tenant did not want to be paying full occupancy because the landlord had not made any of the repairs that they were supposed to. And there was really, really, really serious habitability issues. We did, over the objections of the landlord, get the stay to July 1. We picked July 1, not only because that's when their new apartment starts, but also because that's because the kids are in high school, and this is going to make high school and junior high. And one of the definitions of extreme hardship, if the denial of the request will result in the extreme hardship, is disruption of schooling. So it's a really good one if they've got kids to say, we need to stay this until the end of the school year or the end of the semester, until the next school break. We don't want them to have to miss a week of school or 2 weeks of school in this process, Okay. Those are orders to show cause. The other kind of order to show cause that does come up on an unfortunate amount of time is illegal lockouts or constructive eviction. These are more complicated. You're not going to want to use a little tiny form. We're going to try to get together a version of this for y'all, but really, if somebody comes in and they've been illegally locked out, you should send them to Hiscox Legal Aid Society if they're private pay, or Legal Services Central New York if they have Section 8. The Housing Authority doesn't generally illegally lock people out, so it's not usually a concern.
Treble damages.
Treble damages, that's why you don't want just this. You're gonna need to do the larger order to show cause, you're gonna do a verified petition. It's gonna demand treble damages. There is a new law regarding illegal lockouts that also puts in place civil and criminal penalties. That has been interpreted by the courts to not apply to a private right of action. So don't even bother putting it in. They're not gonna grant it. I don't know who can get the civil penalties. I guess the AG's office could. The DA is the only one that can do the criminal penalties. So we're left with the treble. And if it's really egregious, you can get punitive, which we did the other day, guys. It was crazy. We had a tenant that we picked up in court who had already had their first appearance. And we don't usually take just second appearances because it's like the old days, you're like, pew, pew, shooting from the hip because you don't have any time to prep it. But this client was like, I've been locked out. And I was like, hi, I'll take her case. And over the next 5 appearances, the petitioner continued to lie and say that she was not locked out. They went so far as to give her keys that did not work for the apartment. They claimed they had no access to the apartment. Meanwhile, we were going and taking pictures of the apartment being painted, the apartment being fixed up, and all of her belongings were removed to the tune of a very reasonably underestimated $6,000, which was horrific. And this is like single mom who works as like a home health aide, like she doesn't have $6,000 extra dollars. She told me she was having to replace her 2-year-old's pants, like a pair or 2 every paycheck, I mean, it was crazy. So we brought the action. We got their eviction dismissed as retaliatory because there was sewage in the basement. And that's what this whole thing started about. And also rats eating her child's clothing, folks. It was repulsive. And, but we won the treble damages and we got $5,000 of punitive. So we got a $24,000 judgment against this landlord. And side note, we have subsequently settled it for half the amount for like immediate payment, because who wants to collect? Who knows? It was an out-of-state landlord. It was going to take a long time. So we'll take the money and you take the money and run. Okay. The last thing I want to touch on, we only have 3 minutes. Would it be okay if we go to 11:05? Are people okay with that?
Yeah, for
You got to get out. Okay, I will just really quickly go over 7D in 3 minutes and then we can have follow-up questions. There are beautiful court forms that are very easy to fill out for 7D. 7D is a new right of action that says tenants have the right to sue their landlord to force them to make repairs. Prior to this, only the city could sue a landlord to force repairs. Unfortunately, the governor in her signing memo stripped all the teeth out of it. And so there are no penalties. There was originally going to be penalties. There are no penalties. So really what you're going for in this is an abatement of past rent and a reduction of future rent until such time as the repairs are made. So
you're filing it to ask for those.
That's correct. So we use 7D as a counterclaim, but it is originally intended as a affirmative case. So there could be tenants coming in to file these. In the past, the only way you could have recourse against your landlord, besides calling codes and hoping the city does something, was to withhold rent, which inevitably ended up in an eviction. And too often our tenants
Don't set it aside.
didn't set it aside because they've got $150 extra a month, right? Or whatever. So with this, it gives them the ability to go in and say, this needs to be reduced right now. and they need to be told to make the repairs. And the other thing the judge can do is say, we're gonna have you pay, like withhold the rent. The statute says pay it into the court clerk. Our court can't do that. So the city court can't do that. They don't have a system for it. So we have a attorney-client trust fund, and so we have done that with some of our clients. And so it is an option to have one of the legal aid orgs facilitate the payment of the rent.
So is that a requirement for the habitability defense that you have to put that money into an account? And,
It depends on the judge.
okay,
It's a judge's discretion. It's not a requirement.
okay.
And you
This-
don't have to do it before the lease is terminated.
Or before you have the complaint or something.
No. You don't have to have been doing it. You only have to.
Predecessor to this was Yellowstone cases where you could go to court and get an injunction before the lease was terminated, preventing the landlord from doing that, and then the Court of Appeals reversed itself on that. So this statute basically is replacing
Yes.
that whole process.
I'm not even really familiar with that process, but I believe you.
You should believe. me.
I do. I deeply believe you, and I'm not familiar with that process, but yes, that's what this process does. And so the forms are really, really easy. It's a notice of petition and petition. There's also the option to bring it as an order to show cause, but I'll tell you, if it is so severe that they need an order to show cause, they need to be like banging on code's door, because if they don't have water, they shouldn't be bringing a 7D. They should be bringing a constructive eviction case. That's, if it reaches order to show cause level, there needs to be a different filing, in my opinion. So you're doing notice of petition and petition, super easy. It lays it all out. Couple of fun things about this statute that's good to know. They wrote in a different definition for service that includes simply mailing a copy of the notice of petition and petition to the record on the taxes. So it made it easier, super duper easy. You don't have to, that personal service for these kinds of actions. And so you're just gonna put in, they wanna know what kind of property, if it's one, multiple, more than 4, you put in the tenant's info. You have to list out each respondent, so you can sue many different folks under this statute, not just the owner, but also you can do the mortgagee, the vendee in possession, the assignee of rents, the property manager, basically. Real fun, it's fun. So you gotta select which one, and then for the address type, you can usually, if it's the owner, just do the billing address on the local property. And then they want to know the amount of rent, and then just really simply write out what the habitability issues are. The best thing to do is, if they do have a codes list out the codes list, and then like write out what they mean. Do you know what I
Just-
mean?
Yeah.
Laughing in my mind about you sue the mortgagee.
I know,
It's just-
Yeah.
ultimate, 3 months later, something might happen.
Yeah. Oh, if something happened in 3 months, that would be lightning
Yeah,
speed.
that's it. But it's
And
like
that's what.
Citigroup's gonna come in
Yeah.
and appear.
Yeah. And then in terms of the things that you're gonna ask for, you're gonna ask to order to repair. That's what this is for. So you must click order to repair. I don't know why they make it a click. But then you can say reduce future rent. And then you just do your discretion. You could say 0, but the judge is not gonna order 0. But I have seen her order 50% lately, and that she never used to do that.
And that's also, I see where you're writing
Yeah.
the abatement.
Yeah.
So that's.
Yeah, and then they didn't specifically list out abatement. Instead, what they wrote is, in the way it's written in the statute, is this concept of like a money judgment for the difference between what you paid and what should have been owed. Well, most of our tenants have started withholding rent by the time they get here. So they usually haven't paid the full amount of rent. So you're asking for an abatement of past due rent instead. And then it does have to be verified. And if there's multiple petitioners, each petitioner needs to verify it. One tenant can bring it though. You don't have to, if there's 4 tenants in the apartment, you don't have to have all tenants join in it, okay? There is like a $35 or $40 filing fee, so we do have the application to waive fees. And we did share some more details that the Syracuse Tenants Union put together for tenants. This was meant to be something people could do on their own, so it's got some great description. And then Just Fix New York, which is a cool org downstate, provided to help people do these downstate provided a very detailed list of all the habitability issues. You can use this as a guide when you're talking through with the tenant. You can even just say, if you want, go ahead and check off all the issues you have, because sometimes tenants will say, oh, there's not that, it's mainly the sewage, and then you'll be like, you'll look at the codes report and you'll be like, it says here you have an infestation and also like 5 broken windows, and they're like, oh yeah, those happened too. You know, it's like the hierarchy of the, like, so many of the apartments are so bad that people are they just assume it's gonna be infested, and the assumed windows are gonna be broken, and that's not right, you know? Okay, I already showed you how to look up the IPS. We provided the thing for the tax lookup, which you already referenced, I think, in terms of looking up what the property looks like and ownership. I'm not gonna go through it because we're over time, but if you want training on that, Luz Marina will always be there with you. And I've got Luz Marina's contact info. So I hope you guys will start joining us. We're hoping to kick this off the week of the 20th. On Tuesday and Thursday morning. So we'll be reaching out, seeing if we can get you guys in there. If any of you have to leave, I can stick around and answer questions for a few minutes.
I would suspect that code violations are an event of default under a mortgage.
An event of default.
That's
Under the mortgage.
Fascinating.
Right, so if you're going to serve you're gonna make
Yeah.
the
Hey,
mortgagee,
so nice to meet you.
you should be sure somehow to say.
This is the
that
default on the
yeah,
mortgage.
The land,
Yeah,
my landlord is in default on his mortgage.
yeah, that's fun.
And that
Yeah.
the mortgagee has a duty to
Yeah.
enforce the mortgage requirements.
Yeah,
Which
that's
is much
fascinating.
more powerful than anything we're gonna do.
Yeah, that's true. It is more powerful to
Start
have. a
building
mortgage
a
to do it.
database against one landlord that's
Yeah.
constantly doing this.
Yeah, yeah. Any other questions?
From a practical standpoint, it seems to me like we're probably, unless we decide to take a case further, just gonna be doing answers and maybe once in a while in order to show.
That's
the
correct.
process. Okay.
That's
And then
correct.
we'll probably be doing the other things if we decide to take it.
Well, in the
further.
7D as well,
Right, okay.
potentially.
Yeah.
We're definitely gonna let people know they can go to
Yeah.
this. We have some evening tenant rights clinics too. We have twice a month over at Salt City Market. But this one's gonna be the daytime one, because we're gonna try to hit the tenants where they are.
And we're most likely gonna be getting people who are there for their first appearance?
Most
Or
likely.
are there gonna be folks who say like, I hear you do this twice a week, so I
Both.
missed my court date on Tuesday and I'm here Thursday, can you? follow
Yes,
me?" Okay.
yes, both, because
Okay.
we are coordinating with the court clerk.
Mhm.
And they're very excited about there being help for people who miss their court date.
Yeah.
So it is actually possible there could be a good number of those orders to
Mhm.
show cause to
Okay.
vacate.
Okay. that makes
Yeah.
sense. And are you guys gonna kind of like pre-screen them like you used to do when we would show up?
Yep.
Okay.
Yeah, Luz Marina's gonna be doing the intake.
Oh, I'm
sorry.
Yep, Luz Marina's gonna be doing the intakes.
Okay.
Cool?
And then I always just have this question about like making sure we don't have conflicts. So I assume we're still covered while we're there under the conflict.
That's correct.
rule.
Yeah, I
And
didn't
then
go over
we
the
take it
limited,
further.
that's correct. I didn't
Okay.
go over the limited scope rules, but a quick reminder
Mhm.
is that under rule 6.1, it is a limited scope
Yeah.
clinic run by a pro bono program, so the rules of conflict are relaxed. You don't have to run an actual conflict check back at your office. You just have to do actual knowledge. Obviously, if Buske Holstein is listed as
Yes.
an
No, yeah,
attorney, you
yeah.
wouldn't want to take it. Otherwise, you're all set, and when you come back, you don't have to enter it into your own conflict.
If it's
database.
just Warbeck, I'll definitely show
Hey,
up.
thanks.
Saturday.
Right, but if we wanna take it to. the
Then you
next,
have to
then
do
we
your
need to come
conflicts.
back and-
Yep, that's
Okay.
correct.
So, will we in advance have the court agenda, or will we be seeing it
No,
when we arrive that morning?
it'll be when you arrive, since
Okay.
we're not necessarily representing the people in court.
Okay.
Yeah, we're
So
not.
At least flip through and see if one
That's
of our
fine.
clients.
Right.
I can print out the calendar.
Yeah, I mean, if you
Yeah.
want them ahead of time, we have them. And
Well,
also
then I
they're
know what
available
it
on Web
is.
Civil.
Yeah.
You know,
Yeah.
you can pull it up on
Oh.
Web Civil ahead of time. They're always there.
Do you wanna see somebody sit down?
They're up there 10 days.
I'll just
Yeah.
provide it the day of.
So you know, we used to run them.
Yeah. No, we
Yeah.
have it. We have it.
But
It's
I- but-
just,
But I think sometimes it's, in hindsight, that was a lot to ask of our conflicts people. but
that's
I
how I
certainly
feel.
Yeah.
Look at it and know that.
That's
we
right.
represent, you know, a related entity to one of these
Right.
that has 10 that day.
That's
You know,
right.
and we can just at least know we're not gonna be on the.
Right.
Yeah, that's my feel is like, if you don't have to I mean, you're not making an appearance or anything, you're just helping somebody with a form. So
Yeah.
my preference and inclination would be that you guys don't need to do
Mhm.
the conflict checks ahead of time because you don't know who's coming in. It's not exclusively serving the clients in court that day.
Okay.
But if you want to do it and cause yourselves more work, you're welcome
No, I'm
to.
not gonna do
I
it
just
ahead of
try to
time.
figure
I
out
just
how
don't-
to,
I still don't wanna be sitting there with somebody.
oh
who-
God, no. Yeah,
Right, you're sitting
exactly.
there and all of a sudden they tell you who it's housing visions or
That's
something,
right.
and then you're saying.
That's
okay,
right.
That's
yeah,
exactly.
Yeah, yeah.
Make sure you do the evaluations. Your CLE certificates are up there, so just fill out the evaluations.
Pre-registered.
If you didn't pre-register, then Carrie will.
Out there.
Yeah, she's out now, waiting.
I know.
Okay, well then, any questions online, guys?
Oh, thank you.
Are we all good?
No, thanks, so we're good.
All
Thank
right,
you.
thanks for joining, guys. So sweet of you.
Bye.
Take care.
Bye.